appeal in the matter of Delaney's Nursery Schools Limited and Avondale Park Ltd.
Yes, Mr. Hall.
Lord Lady, I appear for the appellant.
Yes.
My friend Mr. Moffat appears for the respondent. Before I start into the appeal proper, you may or may not have come across an application to reduce further evidence.
Up-to-date accounts.
Yes.
Why is it taking so long?
I have no idea.
I mean, the application was only made yesterday.
Yes, yes. I don't propose to press that application. It's the up-to-date accounts or their preparation is telegraphed in paragraph 32 of Mr. Mowain's statement, which was before the judge.
Yes.
That's now been done. My submission would be it's not really relevant to any matter on the
Right.
appeal.
Well, let's forget it then.
Yes. But I don't challenge the judge's finding on balance of convenience, and it's relevant to that. But I say the judge shouldn't have got there. My Lord Mayor, there are three grounds of appeal. Grounds 1 and 2 assume that the judge was right to apply the serious issue to be tried test, and ground 3 says, in the light of the circumstance, the judge should have looked closer. He should have applied a higher standard. And I will take you to American cyanamide when I'm dealing with the ground 3. I don't want to teach my grandmother to suck eggs. No doubt you looked at
I think
that.
we're quite familiar with American
I haven't assumed otherwise. So I'll start with ground 1.
Yes.
And that is a pure question of construction.
Yes.
And again, I don't want to teach my grandmother to suck eggs, but I've cited both Arnold and Britain and the subsequent Scottish case in my skeleton argument. But it's worthwhile looking just at paragraph 15 of Arnold and Britain, where Lord Neuberger sets out. It's at divider 32.
Divider?
32 of the... Sorry, divider 32, page 440.
Again, I think you can assume that we're
the
familiar with Arnold and Britain.
Yes. It's simply the principles at paragraph 15 there, although Lord Neuberger, what is frequently cited are the following paragraphs, which go on perhaps to put a gloss on previous authorities.
Yes.
But it's the different, the 4 or the 5 or 6 points made in paragraph 15 at page 450. If one then turns to look at the sublease itself, can I take you on a whistle-stop tour of that document? It's at page 60. I have it at page 62 of the core bundle. That's divider 7, page 62.
Yes.
That's the front page. If it goes then to page 67, one will see the parties to the appellant, Melcraft, Mr. Mowain, the respondent, and Mrs. Delaney, personally who's the guarantor. And the background is set out: the landlord's entitled to possession under the terms of the superior lease. The landlord has agreed to grant an underlease. If one then looks at 68, goes over the page, the definition of contractual term is ending on and including 29th August 2022. So given that this was a lease excluded on the face of it and properly excluded from the 54 Act, that was the term date. The permitted use one sees at paragraph page 69, which is as a nursery within use class D1. And then over at 70, one sees a number of potentially relevant definitions. Property is the property. Rent commencement date means 14th December 2014. That date paid in possession shall not have been given by the tenants of the short owner. The date at which paid in possession is given. You have the review dates set out there. Review period defined. And then further down, you see the definition of superior lease.
Yes.
The grant itself, the demise, is at page 71. well. If one goes over the page to 72, one will see a fairly lengthy rent review provision in clause 5, the details of which are not relevant, save that one of the points made, or one of the events upon which I rely in respect to a single mention, but there is a lengthy rent review clause in clause 5 which stretches from 72 to 75. And then we have perhaps the most relevant clauses, which are clauses 8 and 9 particularly.
Yes.
Clause that's 76. 8.1. As soon as reasonably practicable after the date of this agreement, the tenant will submit an application for planning consent in a form to Kensington and Chelsea Council in a form first approved by the landlord, such approval not to be unreasonable or delayed, and use reasonable endeavours to obtain planning consent. But that obligation so applies to tenant to enter into any planning agreement so far. So it sets out the details.
I couldn't find a definition of planning
There
consent,
isn't.
even though it's spelt with a capital P and a
That's
capital
right.
C.
That's right. There are.
But I must have been envisaged that it would be planning permission for a nursery school.
Yes, I think that's accepted. I think somewhere in Ms. Delaney's witness statement she says that it's not disputed that was a planning consent for change of use from residential to Class D1 nursery. Yeah. And indeed, that was applied for and obtained.
Yes.
I think it's on the 11th of December. So that's the obligation. That's an obligation which arises on the date of the agreement in September. And then 8.4, if planning consent is not granted, the tenant may give 1 month's written notice to the landlord terminating this lease. Termination will be without prejudice to the obligations of the tenant and the rights of each party in respect of any earlier breach of this lease, provided the tenant shall not be entitled to terminate this lease in any of the following, if any of the following are in place. And therefore there's A, B, C, and D. Thus, if the planning process is still ongoing, the right to terminate doesn't arise until it's terminated and no planning permission has been granted.
And that's open-ended, is it?
It appears to be, yes. And in such case, the date after which the tenant can terminate these pursuit clause shall be postponed to the date 10 working days after the date of E and F. So that's the point. There's an obligation to use reasonable endeavours to get planning permission. You can terminate if no planning permission. The tenant can terminate if no planning permission is granted. But that termination will only arise if once it's finally decided that planning permission has not been granted.
Yes.
And then 8.6. Well, 8.5 is that the lease is terminated or the tenant will immediately cancel all entries related to the agreement registered. And then 8.6, the tenant agrees the landlord is entitled to keep 50% of the security deposit as non-refundable compensation for the early determination in accordance with clause 8.4. So the landlord gets half of it, about 27,000 pounds, if the tenant terminates under 8.4.
Yes.
And then we come to clause 9, which is the clause. This lease will be terminated immediately if by 14th December 2014 the landlord does not produce to the tenant a certified copy of the complete deed of variation of the severe release, which A, either deletes clause 11 of the severe release or permits the subletting of the property to the tenant on the terms of this lease, and B, varies the permitted use under the severe lease from residential to permitted use under this lease. And that's the clause which forms ground 1 of the appeal. If one then goes, there's some other clauses which are worth, in my submission, looking at. Clause 13, which is at page 79, within 1 month of the end of the term, and notwithstanding the term is ended, the tenant shall make an application to close the registered title of this lease, should any requisitions raised by HM land in connection with the application be dealt with the public property. Tenant shall keep the landlord informed of the progress of completion of this application. There's an obligation to register, and therefore on the termination of the lease, there's an obligation on the tenant to deregister. And in 14, the tenant shall not use the word benefit or other permitted use. We'll see the definition of that. Clause 18 at page 80.
So just
yes.
Pausing for a moment, the lease began on the 9th of September 2014.
Yes.
The obligation to register in clause 10 arose on that date.
Yes, it did.
And so an application for registration was to be made without delay, i.e. whether or not 14th December 2014 had come and gone.
Yes. And indeed the obligation to apply for planning permission arose on that date, and that's one of the points on which I rely. I'll come to that shortly, but yes, that obligation arose, and then there's an obligation when the lease terminates, and it doesn't specify by what means or how it terminates, to deregister.
Yes.
So I forgot to draw your attention to clause 10, but that's my lord has spotted that. Clause 18 puts the rest of the clauses, clause 9, in perspective. 81, the tenant acknowledges the property is occupied under an assured short-term tenancy which expires on 13th December 2014, the assured short-term tenancy. The tenant cannot take occupation of the property until vacant possession is given. The assumption, of course, to bring you off there is that vacant possession will not be given until the end of the assured short-term tenancy. But as we make a point in our skeleton, if vacant possession is given sooner than that, there's nothing to stop the tenant taking up possession. 18.2, the tenant acknowledges that all rents payable under the assured short-term tenancy will continue to be paid to their landlord, provided the landlord shall hold the last month's rent paid under the assured short-term tenancy jointly for the landlord and tenant, and at the request of the tenant, apply the rent so held towards such reasonable and proper costs as the tenant may incur in obtaining vacant possession from the tenants under the assured short-term tenancy, and any such money so held as the case may be, balance thereof shall be released to the landlord if vacant possession be given. So it appears that there's a recognition that the tenant might incur costs getting rid of the insured, or ensuring that vacant possession is given. And then briefly,
that's right, isn't it? The effect of the lease would make the tenant the reversioner on the assured short-term tenancy.
Yes, as a matter of law. Now, whether when it refers to their landlord, that's a reference to, I suppose probably inevitably as a matter of law, it's a reference to the tenant under the sub-lease. That's right.
Yeah.
Yes. Yeah, that's right. The point is that the tenant becomes the landlord of the assured short-term. The tenant's obligation is to get rid of, or technically it's for the tenant to get rid of the assured short-term tenants, and it can, from the last month's rent, it can deduct the expenses that it incurred in doing so, and then who gives the rest to the landlord, or to the landlord under the sublease. For what it's worth, 19.3, page 81, nothing in this lease constitutes or shall constitute a representation or warranty of the property may lawfully be used for any purpose allowed by this lease. 21 is the exclusion of the 54 Act, and it's not said that that wasn't lawfully done. Um, 23 at page 82 deals with the security deposit. The tenant will pay to the landlord security deposit as protection to the landlord for any breach of the security, including non-payment of rent. The tenant accepts that the deposit shall be released directly to the landlord for its use.
There was 59,000.
Yes.
Just yes. You said earlier that 50%.
It's £59,000 it's defined, and that was paid over.
Yes, it's just when you were referring to 50% of it, you said 23 or 24,000.
That's my inept mathematics.
29,500, I think.
It's defined, so my lord, it is. It's my own inept mathematics. 59,000 is the security deposit, and that is paid directly to the landlord. It's not it's not held by any stakeholder. It's paid to the landlord, and the landlord can use it. And 23.2, the landlord's director gives a personal guarantee.
I think in residential leases, there's now an obligation to have a security deposit held by somebody else.
Oh yes,
but it doesn't apply to commercial leases. No.
But absolutely, there's very stringent terms as to where you have to set up you have an independent provider to do it. But that's not the same in commercial leases. 23.4 is the final clause. Draw your attention to Lord's Lady. By the tenants observed with all the terms of this agreement, the security deposit will be returned subject to clause 8.6 to the tenant within 1 1 month following the end of the term, or otherwise such a deduction of cost to liable for any good, any breach, or otherwise compensating landlord's loss. So the security deposit gets returned at the end of the term. There's no provision for interest payable because it's the landlord's. It's simply the security deposit getting paid back 59,000, provided there's no lawful deduction. That's all I want to say about the terms of the sublease. There is a little background. I don't know whether my lords and lady have a look at that. If one goes to the supplement bund, one will see there's some email correspondence starting, I think, in December 2013 between Mr. Moving and the RBKC as to the possibility of the property being sublet for nursery use. It starts at 242. And you will recall that Miss Delaney in her witness statement says, well, I initially approached Mr. Movin in late 2013. We did a deal then, it fell away, and then it resurrected itself sometime in 2014, and that led to the sublease. But if you start at 242,
Yeah.
that's an email exchange in December 2013 to Mr. Mogan and Mr. Bickerstaff of the Goldberg entity Chelsea. Middle of the page, we approached a reputable local nursery to rent Avondale Park Ltd. Would the council then object to this regard? Of course, the correct planning application granted. Further, we almost completed our works to see that deals with other property, and then response at the top of the page the next day. Manufacturer email: if the relevant planning consent is granted, the neighbours do not object to planning changes, then that RBKC will not oppose change to a nursery as long as there's demand there is needed. That's the first stuff. One then goes to, if you go to 243, you see there is correspondence which starts again in May 2014 and goes on to September 2014. One looks at it starts at bottom 243, 23rd May. Dear David, birds eye exchange below would be advised we're in the process of underletting the above property to Mr. Delaney Nursery. They would, of course, make an application to the council for D1 use, which we understand the council has given strong indication not to oppose, to keep you updated. And then there's another email at the top.
Yeah.
I think that then over the page. I don't take you to waste your time by looking at this. The point is, there is an exchange of emails which goes on till September, goes to page 251. So yes, it's 249. And this is, the middle of it is an email from Mr. Movin's solicitor, that's Vitalis, this DNL, 12th of August, to Mr. Bickerstaff, again, this local authority. Can you please confirm whether the council are utilising their own deed or using mine? The firm when expect final documentation for signing. Perhaps you'll be kind enough to call me the number we'll discuss. And then on the 12th of August, Mr. Bickerstaff says RBKC will use their own licensed document. What is the little progress, and let me take responsibility for this. Are you happy to cover the reasonable costs of the licence?
So it's a license to underlet.
That's right, yes. It's a deed.
So it's not actually a change of use, license for change of use, or is it?
I think it's meant to be both. That's the point. They're negotiating this at this stage.
Well, back on page 245,
Yes.
Mr. Bickerstaff said the rent number to change to reflect that.
Oh yes, yes. It's clear that at least one of the reasons why the deed of variation was not produced, not obtained or produced on the 14th was that although in this correspondence the local authority had indicated that as a matter of principle they were content to allow the property to be used as a nursery, they thought, well, they should get more rent
Yeah.
from that because they thought the the rent that my client was getting was merited a higher rent on the lease. And that's clear. I don't deny that. But the point is that, I mean, I suppose from my point of view, the point is, one, the process of obtaining what's referred to as a deed of variation had started.
Yes.
There was contact with the local authority. They had indicated that as a matter of principle, they didn't object. And the solicitor, the landlord solicitor, my client's predecessor solicitor, was involved in negotiations with the local authority. But it's right to say that, and that's reflected in the 1st of September. You go to 251, you see Mr. Movin says Mr. Dix that there's a whole email to that extent. There was a debate about whether, as a condition of formally granting consent.
No, I was just picking it up because in answer to my lord, you said that page 250 was about the variation of the lease as well, but there's no indication so far that the borough has dropped its requirement of a rent increase.
No, I accept that. I don't say. I mean, whatever happened, no rent increase was ever agreed. And as you'll see from the correspondence in this particular letter of the 9th of August 2022, the local authority were well aware that the nursery had occupied, and didn't object. As a matter of fact, they took no steps to object at all. But yes, you're right that as at the date of the grant of the sub-lease, and indeed as at 14th of December 2014, there was no formal deed of variation, because there was, the evidence is there was still an ongoing debate as to whether my client should pay an increased rent on the head lease. That's the background. I mean, that might explain why perhaps clause 9 was slightly more brief than clause 8. The next, I suppose, 257, no doubt, my lord and lady are well aware, 257 is the Planning Commission. That's 11th of December. And that grants change of use from Class C3 dwelling house to Class D1 non-residential nursery school. And then we get the email exchange at 261. Here's evidence. Possession being taken, factual possession, 18th December. Dear Francis, trust you're feeling better. I met Raoul today to handle the property. He's acquainted with the alarm system, has changed the code. ADT continues to has a program system to suit you. Fully realise you have CCTV. I'd also be grateful if you could bring the attached rent demands to the attention of the accounts. Our bank details as follows. Wish you and your family a very happy Christmas, prosperous New Year. Then the response is at the top, dear Amir, thank you for those. Set a bank transfer up. You can identify any payment made on That would appear to evidence that possession was taken. I think whether it's the 17th or 18th, but that's the day. And at the date of the sublease, both parties had instructed solicitors. I will turn now to deal with the construction of clause 9. I make two alternative submissions, or submissions are shown. First of all, I say that the words are clear. The phrase, this lease will be terminated immediately, presupposes that there will be some step taken to terminate it. As we say in the skeleton, the word immediately is there to contrast it with the notice period set out in clause 8. Therefore, it is terminable forthwith on notice. And we say that's the clear meaning of the words.
And that comes from be terminated, does it?
Yes.
If the clause had said this lease will terminate, then your argument couldn't run.
That's it.
Is that an obligation? Is that the same as the tenant will terminate the lease?
Well, it's not an obligation, we say, it's a choice. My primary submission would be this clause benefits the tenant. If you look at the clause, give me a minute. If you look at the clause, this lease will be terminated immediately if by 14th December 2014 the landlord does not produce to the tenant a certified copy of the deed. So it's not only obtaining the deed, it's production of the deed to the tenant. So by the date upon which the tenant is actually on the terms of the lease to go into possession, the tenant is entitled, if it hasn't seen the relevant document, to say no.
What about the landlord?
Well, that's my alternative submission, is it could be said that the clause benefits both.
Yes.
Well, it does, because otherwise the landlord will be in breach of covenant.
Yes, the landlord will be in breach of covenant. I mean, it might be said the landlord's in a better position, because if the landlord under the head lease, the freeholder, took steps against the landlord, my client as the mean landlord, then the mean landlord would be in a better position, because the mean landlord could terminate the sub-lease. I mean, there's that Hemingway and Dunraven case whereby both parties to this sub-lease knew that the head lease permitted only residential occupation and took that risk.
Well,
but
the use covenant would have been directly enforceable by the local authority against the nursery.
Yes. And indeed, I think is it Hemingway that says that there's an injunction that the landlord, the head landlord, could obtain an injunction against both to force surrender of the sublease.
Yeah.
So yes, both parties are at risk, although the tenant is somewhat more at risk, because the landlord can take steps to preserve its head tenancy by effectively getting rid of the subtenancy, or by compelling the tenant, Ms. Delaney, to use it only for residential purposes, which would render it useless.
Couldn't use it for residential purposes, because it's only allowed to use it for the permitted use, which is a nursery school.
That's right.
So it will be useless.
Yes, well, it would be, I suppose, thinking of it, it would be difficult if the head landlord said to both my client, or my client's predecessor, and Miss Delaney, right, you've got to use it for residential use. It might be said to be a little harsh for my client to insist to Miss Delaney, no, you've got to use it for the permitted
Well,
use.
that's what the lease says.
Yes, it's what the lease says, but it's at that stage, it's my client knowingly causing a breach of its head lease. But yes.
And if negotiations with the local authority for the grant of this deed of variation failed because the local authority was demanding some increase in rent which your client was unwilling to pay,
yes,
there might also be a reason why the parties agreed the lease was to simply terminate.
Yes. I mean, the key here is whether the clause affects an automatic termination.
Yes.
Or whether it gives either one or both parties an option.
Right. I mean, there's no conceptual difficulty about an automatic termination, is there?
No, there's one of the cases my learned friend cites, which is
ancient case.
The Gillenhammer case, where that was a case where the court found on the correct construction of the laws, both parties had assumed the risk that it wouldn't happen, and there was an automatic. There's no conceptual difficulty. It has to be specifically spelled out. I think that's what the authorities we cite would say, and I say it's not the case here, because there's distinct. If it is the case, as I say, for example, the tenant the lease has started. It's been registered. The tenant is under an obligation to use reasonable endeavours to obtain planning permission. He's got to spend time and money doing that, and that has to be from the start.
Yeah.
And you say there's no serious issue to be tried on this construction point?
No. Well, I say three things. One, the judge actually didn't apply that test.
Well, he said that it meant what it meant.
Yes. I mean, he says there's a serious issue to be tried on the Javid and Ackle point, the Walgian Mine Cook point, but he simply says in his judgment that
automatically terminates.
It's automatic terminates. He doesn't say there's a serious issue to be tried. He says no, it's automatic. That's what it is. He appears to come down to the clear view on the face of it that that's it. Secondly,
you showed us Arnold and Britain, and you said the language was clear, but as a matter of grammar, to say something will be terminated does naturally mean it will come to an end, rather than both or one party will have the right or option to terminate it. I mean, if that had been what you wanted to say, you could say it was terminable.
Yes, well, I accept that there's several learned books and authorities which say that an argument that you could have said it more clearly, or if they wanted to say X, they would have said X.
It's not a very strong argument.
We are what we are, unfortunately.
I mean, you're concentrating on be terminated, but it's will be terminated, not may be terminated. This is what will happen.
Well,
on the 14th of December.
Will be terminated. I mean, you could say, I suppose my second submission is it's ambiguous. Right. It shall be, it could mean shall immediately terminate.
Yes.
Shall cease automatically.
Yes.
Or shall become null and void. That's one potential meaning. Or, as I would submit, it could mean shall be terminable forthwith. That's the other meaning. And insofar as, this is why I took you to Arnold Britain, insofar as it is ambiguous, I would say the clear meaning, or the meaning that the court should choose is the latter.
It would be a very odd option to terminate, which required no notice period at all.
It might be, but my lord, given the circumstances, that's the case. On the 14th of December, the tenant was due to take up vacant possession. It was assumed that the assured show-told tenants would leave. Before it did that, and then it presumably spent money, as it turned out, refurbishing the premises or making alterations to turn them properly into a nursery, it had the option. Right, I've got the planning permission. Now, have you got the landlord's consent such that I can lawfully occupy and pursuant to my sublease under the terms of your head lease?
Right.
And that would be
and suppose the landlord says, no, I haven't got it yet. I'm negotiating with the local authority. They want some unaffordable rent rise. I'm going to try and beat them down. So give me a few months and we'll see what we can do. And you say, well, after all that, the landlord can say, well, no, I couldn't get this. Couldn't shift the local authority, you're out. Now, immediately.
No, the tenant has a choice. My primary
Why the tenant?
Well, because it's for the tenant. Well, both parties have the benefit. I mean, otherwise, it's simply, there is no deed. Doesn't matter what the reason is. It may be good, it may be bad, it may be indifferent, but that's it. Once there's no deed, bang, that's the end of it. Despite the fact that both parties might want it to continue. Despite the fact that the tenant has spent maybe hundreds, thousands of pounds obtaining a planning permission, despite the possibility the tenant might have gone in beforehand, and because the assured short-told tenants have left and commenced works. And there is no choice for the parties. That's the judge's alternative. There's an automatic termination whether the parties want it or not.
How long does the right of termination subsist?
Well,
picking up my lord's point. Obviously, what was contemplated was a short-old tenant called vacate on the 13th. On the 14th, Mr. Delaney will go into occupation. By that stage, there'll be a deed of variation.
Yes.
And I understand entirely your position is, if there hasn't been produced to the tenant by the 14th, the deed of variation, the tenant has a right to say, actually, I don't want to go in, you haven't managed to vary the lease. Fine. But suppose that the position is that the landlord says, no, I'm just about to get there, bear with me. And the tenant thinks, well, I've spent all this money getting planning permission and opening the school and so on. I will trust the landlord to get it and go into possession. How long can the tenant keep this option alive and eventually say, you still haven't got it, I'm putting it out?
I said it's only until they go in.
Oh, it's till they go in. So they could have done this on the 18th here.
Yes.
But not on the 19th.
That's right.
Where'd you get that from?
Well, it's my construction of what it's a right that arises, the tenant. And the whole point, the background is that the tenant's about to go into occupation. That's the contemplated date of occupation. It's the 14th of December.
But I thought you said it could go in. The tenant could go in well before then.
Yes. But that's the point. That's why the date of 14th. But ask oneself this. What is it on the 14th that the lease, the sublease contemplates happening? That is, tenant going into possession. Now, the whole point of the clause is that, as the judge reads, if there's no deed of variation the 14th, it finishes. That's it. The tenant can't go into occupation. But I say the proper construction is that the tenant is given a choice on the 14th.
Exercisable on the 14th.
On the 14th or before it goes into possession.
Why the latter?
Well, because that's
Well, the difficulty is you can't keep it open forever.
No,
so
that's the point. The whole point of this is the 14th is the date the tenant goes into possession. And, okay, it might be said, well, Mr. Holland, that's a very strict notice period. It's a very short notice period you've given. But it is a short window because the phrasing of the clause is such that the tenant must know one way or the other. The tenant either has a deed or has seen a deed or it hasn't.
The AST expired on the 13th.
Yes, it did.
So the tenants under the AST refused to go.
Yes.
As contemplated.
Yes.
Tenant has to spend money to get
Yes.
them out.
Yeah.
Goes off to the county court, gets an order for possession from the district judge, and the order takes effect on mid-January, let's suppose. Is that option still exercisable? Because the tenant goes into possession in January?
My primary submission would be yes, because possession.
But I thought you
hasn't
just
been-
said it was the 14th of
Yes. Well,
December.
yeah.
14th of December or such later date as the tenant goes into possession.
Yes, as the tenant. Yes, that's what. If you're looking for to say, if you say, look, 14th, it's either yay or nay on that date. You might say, well, that's a very short window. But what's the point? What's the clause getting at? The 14th is the date that the parties contemplated that the tenant would go into possession.
Right.
Now, you could say it's a very short window deliberately because there's either is a deed of variation on the 14th or there's not. And if there's no deed of variation on the 14th, the tenant can say, right, I'm not taking the risk. The tenant has the option. I'm not, right, sorry, I know I've spent all this money.
So it's really, on your submission, an option for the tenant to say, actually, I don't want this lease.
Yes.
Before, but once you've gone in, that's it, you've lost your option.
That's right. You have a short window. The tenant's a short window of saying, right, do I take there is no deed of variation on the 14th. Now, I'll come to debate whether there's any obligation on the landlord to produce a deed of variation by the 14th. There's no express obligation, unlike there's various places in the sublease where there's obligations imposed to use reasonable endeavours on both parties. But there's no express obligation on the landlord to do anything in respect of the deed. Now, as we speculated, on one construction, it might be said that there's an implied obligation to use reasonable endeavours to do that. Because otherwise, the landlord can simply sit on its hands and simply say, all right, I'm not going to do anything.
But then it loses, I mean...
Yeah, but it gets the benefit of the tenant's planning permission. Well, the tenant tenant's obliged to get planning permission. It gets it. The landlord says, well, I haven't done anything to get the deed of variation. But thank you very much indeed. The lease is terminated.
That would be quite a cynical exercise of the landlord's position.
Yes, but on the judge's construction, it's perfectly possible. It automatically terminates.
Surely it's more reasonable to assume that what the parties expected was that both parties wanted the variation to take place. So it's in the landlord's interest to get a deed of variation, because otherwise they might lose their tenant. And the tenant is paying quite a substantial rent, which is more than the rent that the landlord's paying.
I accept that. I mean, but the question is whether there's an obligation.
Well, yes. It may be said you don't need to imply an obligation because it's in both parties' interest to do it.
Yes, but otherwise it might be that the landlord might say, well, I'm not doing it. Or I've got one, but I'm putting it in my jacket pocket and not giving it you because, quite frankly, you've now got planning permission to turn this into a nursery. Thank you very much. The planning permission attaches to the property, I'm terminating the lease, or I'm effectively terminating the lease by not either having got a deed of variation, or having got a deed of variation, not giving it to you because they have to produce it. And now I've got a property which can be used for as a nursery, and I might run my own business from it. I might find a more profitable use for it. And that's the possibility which the judge's ruling, in fact, it gives you. And that will occur whether both parties want it or not.
Yeah.
And it will occur no matter what the reason for my client not getting the deed of variation, good, bad, or indifferent. And therefore, the point of this, we say, is to give the tenant an option as at that date. That's the date I'm due to go in.
Yes.
I mean, and it's a fairly draconian provision, because it provides that a lease which has otherwise commenced, which has been registered, in respect of which the tenant has started preparatory works, I got the planning permission, comes to an end. And that's a fairly draconian position, and that's perhaps no wonder that there's a short window in which that option can be exercised. And that's the point.
Right.
So it's either clear, and if it's not clear, it's ambiguous. And if it's ambiguous, we say the court chooses the more commercially sensible construction, which is that it's an option primarily for the tenant. It could be said, well, it's an option for both parties, because both parties would be technically in breach, as pointed out, because my client the nursery would be occupying technically in breach of the head lease.
Yeah.
And one party or the other might not want to take the risk. And yes, it may be that the parties think, well, the tenant hasn't vacated, the subtenant, I'll expend further sums in getting rid of the tenant. Or it may be that the tenant might listen to the landlord's blandishments and say, yeah, I'll take the risk that the landlord will get the deed of variation. Or I'll take the risk that whatever they're saying now, the Royal, as it turned out, the Royal Borough of Kensington Chelsea actually wants a nursery in there and is not going to take steps to evict or compel the landlord under the head lease. But that's the point. So it's either an option for the tenant, or it's an option for both parties, but it's an option which has to be exercised, we say, because it makes no commercial sense that it simply ends like that without. And one could imply an obligation on the landlord to use reasonable endeavours to do that, and if that's right, then a tenant, if the landlord said, right, well, I'm sorry, there's no deed of variation, I'm terminating, the tenant could say, no, you've got no right to, because you haven't actually made sufficient efforts to get the deed of variation. I want this lease to continue, I'm very keen for this lease to continue, so you're not you cannot lawfully exercise that. So I suppose the point is that it is unattractive commercially, the judge's construction.
Yeah. Understood.
Can I now take you to 3 or 4 authorities on I say there's a string of authorities which similar clauses. I accept that ultimately this is a question of construction of the individual clause in this lease, and as I've conceded, it's perfectly possible conceptually to draft a clause which automatically.
Yes, I mean the cases that you refer to are all illustrations of the principle that you can't take advantage of your own wrong.
Well, some of them go further than that. Some of them say that you can't take advantage of a situation which is within your own hands to bring about.
Yes.
It's not the same thing, because if it's in your own hands to bring it about, it may not be a breach of contract.
Yes. Well, that's not the case here, is it?
Well,
your clients could not have brought about the deed of variation because the borough had to agree on such terms as it thought fit.
Well, it could, in the sense that it was its job to use a neutral phrase, it wasn't the tenant's job to go to the local authority, the landlord, or the freeholder, and get a deed of variation. That was impliedly in my client's
Yes.
hands. And therefore, in that extent, it was in my client's hands. It was to do the work to do that. And it would be, for example, if one was going to apply a term, it would be on my client to use reasonable endeavours to do that. My client could have, because quite frankly, it could have said, yeah, okay, I'll cave into your demands, and yes, let's get the deed of. I'm so desperate to get this deed of variation, I will agree to the increased rent under the
Well, that
lease
would
as
depend
condition.
on whether the reasonable endeavours implied obligation extended to require the landlord to pay whatever it was that the local authority demanded.
Yes, I accept that. But I mean, well, if you imply a term, these reasonable endeavours, then in my submission, this is a clause which would allow the landlord potentially to take advantage of its own wrong.
Yeah.
By failing to use reasonable endeavours, or by and then simply saying, sorry, thanks for the planning permission, thanks for any refurbishment you've done, the lease is terminated, and I'm going to re-let it to someone else. Or I'll re-let it to you, but I'll let it at a higher rent to you, please, because the lease that you've agreed is terminated.
Right.
Can I just take you to some of the authorities, my lord? I accept that many of them say that it's based on the principle of taking advantage of the law. If you go to, start with Davenport and the Queen, which is divider 10. And this is divider 10, page 116.
Yes.
And this is it's a term imposed, it's a statutory term.
Mhm.
And the statutory provision is on page 122.
Yes.
Section 8, any person selecting lands in an agricultural reserve shall fail to occupy and improve the same as required by section 7 of this act. So I'm reading from just above,
Yeah.
above that.
Sideline bit.
That's right, I'm grateful. The land select shall cease and determine, and the amount of purchase money less by one fourth part should be refunded to him and issued by landlord entitled to the permission to be force on sale. And then on goes to it's 125. The line bit, the forfeiture insisted upon by the Crown is the failure of mayor to cultivate and improve the allotment in the year 23rd September 1867. The application was declared at sea. 25 failure happened if the appellant contends of the rights presently referred to, forfeiture is not thereby incurred. Clause has been waived, relies more on certificate granted by the Commission of Crown Lands. And then if one goes to page 128, which is 129, page 128 or 129 bundle. Right at the top, in answer to the defence that if a forfeiture had occurred, it had been waived by the receipt of rent, it was contended on the part of the Crown. The effect of the provision made in section 63 was to make the lease absolutely void and unavoidable. The Supreme Court took this view, further decided that Leicester having imposed a condition, the Crown would dispense with it. And then the decision is that the line bit towards the bottom of that page, and particularly the last paragraph. Does then the proviso of forfeiture in section 8 of the Reserves Act, when read into such a lease as the present, make the term so factually void or voidable only upon a breach of condition? In long-said decisions, the courts have construed clause of forfeiture leases declared in terms however clear and strong, they shall be void or breach of conditions by the lessees, to mean that they are voidable only at the option of the lessors. Same rule of construction may apply to other contracts where a party finds that conditions sought to take advantages of to annul the contract. And there it cites Roberts and Davy, which is one of the cases which we set out in Skeleton. Then towards the just beyond the middle of the page, it says there's a small paragraph. There's no doubt that the scope and purpose of an enactment or contract may be so opposed to this rule of construction that it ought not to prevail. But the intention to exclude it should be clearly established. And the rule of construction is the one that it's voidable. Void. then again over the page at 131.
So the question which Sir Montague poses is whether it could have been intended that the lessee should be allowed to take advantage of his own breach of condition, or as it has been termed, of his own wrong, as an answer to the claim of the Crown for rent.
Well, yes.
That's the question.
Yes, but if you look at section 8, which is the
Yeah, well,
it's, sorry, Mark.
You showed us that. Yes.
Yes. Well, it doesn't. It doesn't impose any specific obligation.
No.
On
it says if you
it
don't.
simply says if you don't do it, then yeah.
Yeah.
It does talk about failure,
It's,
doesn't it?
yes, but there's a failure to do that, but it's not. There's no obligation to do it. It's simply that if you don't do it, the section 8 applies.
Yeah.
So section 8.
Is that right?
Well, I may be wrong. My lord, I
It's,
thought
the facts are a bit complicated because Section 8 applies, I think, to people applying for freeholds. And then there's a lease, and the lease is treated as incorporating.
that's right. There were subsequent acts to that. I tried to keep it simple in my own mind because you're right. The statutory provisions. There's a
Yes, but you see at page 129 of the bundle, in the first sideline paragraph, the lease includes covenants by the lessee or observance of clauses, conditions and provisos in the acts with a distinct covenant to cultivate 1/6 of the land. So it's not obvious to me that this wasn't a case of
Failure.
termination for breach of covenant, in which case it's not difficult to see why you should treat it as a normal forfeiture clause.
Well, my lord, I accept that. But my lord, the point I'm trying to make, I suppose, from this is that by this stage, that gets to be a rule of construction, as referred to at page 130 of the bundle. That's halfway down, and at 131 of the bundle, having regard to these considerations, the intention of the legislative country does not, the lordships, who so clearly appears to exclude the usual equitable rule of construction.
Yeah.
Except there, it said, well, you can't take advantage of your own wrong.
Yeah.
It's a usual and equitable rule of construction. But if one goes to, can I then go to Kennel and Ward, which is divided 14? And that's another boundaries.
Yeah.
As you see, the facts are set out in the head these. And the clause, if the said lessee shall cease for the space of 2 years to carry on mining operations on such premise, then this demise shall become absolute forward, and these presents and the term hereby granting all rights, privileges, and authorities hereby granted shall ipso facto expiration of time aforesaid cease and be void. And one then goes to page 163 of the bundle, which is page 227 of the report. And you, sorry, it starts at 162, sorry, of the bundle. The line, contest forfeiture of the lease by breach of the proviso may be first, nor if the appellant succeed on this point is necessary for them to show that the failure to work rendered the lease void without any option on the part of the lessor. According to their contention, therefore, on the expiration of the period during which no work had taken place, the lease must automatically end, and any injunctions have been shown that the client must have been in the form of a new lease and not a continuation of the old. And if the covenant does not affect this, then although the word used is void, it will be void, or another is void. I mean, that's exactly the argument here. The lordships have no hesitation saying that if truly of substantial obligation, of course, one let's see on the term of lease, and it would not be consistent with the ordinary rules of construction applicable to such a document over these obligations. Let's see if it's of course possible to break the lease, but this must have the effect that would result if the term was then term was yet to be applicable and condition solely in the power of the lessee. This, however, is not the language used in the lease. The words of the demise should be absolutely forwarded on this follow the provisions of the term should ipso facto cease and clause of the principle be made. Those latter words only give emphasis to the phrase as forfeiture. This is the forfeiture right held by the lessee back to the lessor. The lordship's opinion in this clause, though strongly expresses nothing but a condition of forfeiture, which the lessor is not likely to take advantage if it can judge the clause be required by the expression of their opinion concerning that which case no act was done by the crown to establish forfeiture, as until such act took place the term was not cited. Was not it? They refer to the well-known rules of construction.
Yeah.
Can I take you to one further, or two further cases. One mainly is the New Zealand shipping case, which is at Divider 13. And this was a case where the Privy Council, the House of Lords, held that a contract to build a ship was automatically terminated. It was terminated by the event of the happening of the First World War. And the head note is lined.
Yeah.
And the contract is 2013. And the relevant clause, I think, is at page 146 of the bundle, page 4 of the report. In case the builders become bankrupt or insolvent or shall fail or be unable to deliver the schemer within 8 months from the date agreed by this contract, thereupon this contract shall become void and all money paid by the purchaser shall be repaid to them with interest accrued thereupon 5%, not without it being necessary for the purchaser to take any legal action to recover the money. Builders will hand the purchasers the guarantee of a bank who will undertake to repay the money in the event of becoming due as stated above, except only in the event of France becoming engaged in the European war, and the above limit of 8 months shall extend equal to the duration of said war, but no less to exceed 18 months in all. And then the factor paragraph, the one from the bottom, the vessel was in course of construction on 2nd August 2014, France became engaged in the present European war. And if you then go to page 148, it's 147. I start at 147 on page 5 of the report. On the second point, I also go to the unbound courts below. Here's one of the facts on that special case. The builder was in no degree responsible for the delay which faced completion, and it was due entirely to causes beyond his control covered by the contract. Under these circumstances, the builder is entitled to say that under clause 12 the contract became void when the 18 months expired. Clause 12 deals with 4 different cases: A, bankruptcy of the builder; B, insolvency of the builder; C, failure of the builder to deliver; D, inability of the builder to deliver. It seems to be clear that the builder could not say that the contract was void in consequence of his own bankruptcy or insolvency. As for this, he would be as between himself and the building owners responsible, even if bankruptcy or insolvency were entirely due to unavoidable misfortune. Nor could the builder claim a right to treat the contract as void in case of the failure to deliver, word use of French is and a breach of contract, whether by actual or refusal of permission to perform, cannot confer any right on the person's fault. Force case relied for inability, in the French word it uses impossibilité, and might be due to failure on the part of the builder to proceed with the construction of due diligence, in which case the builder could not claim release from the contract clause. On the other hand, the inability may have been the result of causes beyond the control of the builder, which is not as part of the terms of the contract held liable. It's a principle of law that no one can in such case take advantage of the existence of a state of things which he himself produced. And then they refer to Roberts and Wyatt.
So that's the principle of the law that he's applying.
Yes, and so the point, I think it's repeated there in other places. The point is two for one. If you look at the clause, they're saying there are a number of reasons why the contract said to be void.
Yes.
Number of reasons why, and it depends upon the reason
Yes.
why. And if the reason is, as I said, is something which you could, the existence of state affairs which you yourself have produced, then you cannot take advantage of that. If, as in the case of war, which has got nothing to do with them, then it will automatically void, and that was the point. And I do say the existence of a state of things which he himself, which is not necessarily the same as a breach of contract. That's the point. I say here, by analogy, it was upon my client to get the deed of variation, produce it, and if he didn't, then he's not entitled to say, well, the lease is terminated, I couldn't get the deed of variation. It wasn't for me to do it. Whether or not it's a breach of contract doesn't matter. And the same principle applies here. Therefore, it's the option of the tenant to say, well, I know you haven't got it, but I'm going to go in anyway because I'm going to take the risk. Otherwise, it's whether or not it's a breach, and that's the point. Whether or not you can say there's an implied term on my client. Just
So client uses reasonable endeavours to get the deed of variation, the borough won't play ball, so no deed of variation is produced. Your client can't say the lease is terminated, but the tenant can. Tenant says, well, the borough's got no objection to me being here, so I will let them forfeit your lease, landlord, and as a subtenant apply for relief against forfeiture, which the borough won't oppose, and will clear you out of the way. That's how you say the clause works?
Well, it might do, yes. I mean, it could be. It's either that, but that's the point. It's a risk of the tenant takes the risk. Otherwise, as I say, it might be the option of both parties, or either party. Either party, but the landlord might say, well, look, I've tried my best. I can't get the deed of variation. Royal Borough of Chelsea being utterly unreasonable.
Yeah.
They don't mind matter, but I'm not prepared to take the risk, so I'm going to terminate. But if both parties say, well, okay, let's say what's the situation? Royal Borough of Chelsea haven't given a formal deed of consent. I've got my planning permission, so they're happy qua local planning authority. Yeah. They've indicated to you that they're happy in principle. They're just simply trying to extract more money from you onto the head.
Well, what they said was if the neighbours don't object.
Yes.
So the planning permission's granted, the neighbours put up vociferous objections.
Well.
Then what?
Well, you put the neighbour, I would submit that that's probably in the context of the planning application. The neighbours, that would be the context in which they would object. Those.
Well, that's not what Mr. Vickerstaff said in his email.
Well, yes, it's true that the email said that if the neighbours don't object, but, well, okay, suppose the neighbours do object. The landlord and tenant sit there 14 to 7 say, right, well, look, we've got our planning permission. We want the lease to go ahead. It's a decent rent for you. It's a decent premises for me. The Royal Borough of Kensington and Chelsea are objecting. Now, what do we do about it? Do we? They're objecting because certain local residents have objected to a nursery scheme. But what do? Do we either walk away or we take the risk and go ahead? But the judge's construction is simply, but that's it. There's no option. It just terminates.
Yeah.
And I would submit I made this point. The commercially sensible construction.
No,
is
I think
either it's an option.
Got the point.
Yes. The point. So I think the reason I draw attention to this case is that it may be said to be slightly wider than breach of contract. It's a situation which a party can't take advantage of a situation which it's for them, which they have produced. Now, I suppose you might say, well, that's basically the same thing as a breach of contract. It's not not how it's expressed. It's how it's expressed in the earlier cases, but that's not what the opinion says.
Yeah.
And again, the same thing occurs if you go to page 150. Sorry, this is Lord Delaney. At the bottom, questions of this sort have often arisen in the case of provisions that the lease should be void for non-payment of rent or non-performance commons by the lessee. It's always been held that the lessee cannot take advantage of his own act or default to void the lease. The expression generally employed has been that such a party takes the lease void or less or void, and so on. Decisions on the point of uniform really illustrates the variable principle laid down by Lord Cook that a man shall not be allowed to take advantage of a condition which he himself will provide. Present case is no way responsible for non-completion within 2 months, used by clause of Welsh of the term of governmental meaning. And then over the page, Lord Atkinson, 151, bundle, page 9 report. Person now large paragraph. It's undoubtedly competent for two parties to contract to stipulate by a clause in it that the contract shall be void upon the happening of an event over which neither of the parties shall have any control, cannot bring about the event to retard. For instance, they may stipulate that rain should fall on the 13th day after the date of contract, the contract should be void. Then if the rain did fall on that event, the contract would put an end by this event whether the parties so desire. No, of course they might during the currency of the contract rescind it and enter into a new one, or it's a avoidance immediately enter into the contract. But the stipulation be the contract should be void on the happening of event which one or either of them can by his own act or omission bring about, then the party who by his own act or omission brings about that event cannot be permitted either to insist upon the stipulation himself or to compel the other party whose blame is to insist upon, because to permit the blame party to do either would be to permit him to take advantage of his own wrong, in the one case directly, in the case indirectly, that way, either way. The only other case which I was going to draw your attention to is the more modern, the Gillenhammer case, which is a divider 18, and that was a shipping case in which Justice Hurst, as he then was, did find that there was a clause which resulted in automatic.
Well, that's a question of construction of the particular clause in that case.
That's right. But
Do we get any principle out of it?
Well, no, it's simply, it's interesting to look at the reasons why Mr. Justice Hurst found that there was an automatic termination, and it had to do with this. For example, one of the reasons was the specific wording of the clause itself.
Right.
The clause itself is Article 23, which is
Sorry, which tab are we in?
sorry, we're in tab 18, my lord. I'm
18,
sorry, I'm
yep.
gabbling. It's the bottom of the right-hand column on page 208 of your bundle 407. Entering into force, this contract is subject to, and there's a number of three different eventualities. And then it says, if A and B above are not obtained within 30 days of the stage of the contract, or if the date of the contract, the first installment as per Article 5A is not payable in 10 days, its due date. This contract, unless otherwise mutually agreed, shall become null and void. Now, there were a number of arguments put up as to why it wasn't an automatic termination. Those were rejected. And the reasoning that the judge gave is at 217 of your bundle 416. In my judgment, this assumptions approach is the correct one for a number of reasons. I think I counted it 5 or 6 or 7 reasons, but one of them is the wording of the clause itself. You look at if you look at midway down the left-hand paragraph, the title of Article 23 itself and its opening 5 words are to my mind of crucial significance when used in the subject. So Aiken's construction of that gives no proper weight to those words. Subject discussion would be much more difficult to state if the clause of application after a stage which either side would have embarked on substantial commitments, but that's not the case here. And even if the buyers of clause C after those produce letter guarantees, such a letter would exile wholesale and vital. And another reason, which you see at the top of the right-hand clause, is furthermore, about 10 lines down. Furthermore, my judgment, the words unless otherwise mutually agreed show that it was not the intention of the parties in the contract should be only avoided by the innocent party for the reasons given by this assumption. So yes, my lord is right that it's a case on the construction of an individual clause, but it is one where it was found to be an automatic termination, but it was very different circumstances. And I think the point is that it's only in very extreme circumstances where courts have been prepared to find that a clause does affect an automatic termination, whilst conceptually possible, courts have lent against it.
Yes.
Now, my lord, that's all. My lords and ladies, that's all I propose to say on ground 1.
Thank you.
I'll deal with the proper test in ground 3, but can I deal now with estoppel by convention?
Yeah.
Are you,
Sorry. Go on.
I was going to say, are you inviting us to reach a final view on the question of construction, or
Yes, under ground 3 I am.
Yes.
But under ground 1, I am inviting you to say that there's no
serious issue to be tried.
serious issue to be tried. I try and get it in by the back door on ground 3 by saying, actually, given the circumstances, this is a point of contractual construction where the court, given the circumstances, ought to come to a clear view one way or the other. Indeed, what's slightly strange is that's what the judge appears to have done. If you look at his judgment, he's clearly aware of He's clearly aware of the test and goes to page 44 of the core bundle.
Yes.
It's very important. The first issue which I have to consider is whether there's a serious issue to be tried. The claimant had and has a continuing right of occupation after 30th August 2022.
and he deals with the construction of clause 9 at 18 and 19.
That's right. And having dealt with 18 and then 19, in my judgment, the effect of clause 9 is clear and is automatic.
Yeah.
So it doesn't purport to say, I mean, it's an extemporary judgment after a 3-hour hearing, so it's difficult to criticise in a way, but he doesn't, looking at the judgment, purport to say there's a serious issue to be tried as to clause 9. He's supposed to say it's clear and automatic, and therefore, as he says in paragraph 24, when he deals with counsel's waiver argument, I have no quarrel with the principle Mr. Pett cited to me. However, in my judgment, they have no application in the present case because clause 9 of the lease is automatic in effect. Once it's taken effect, there's nothing for the claimant to waive.
Yeah.
So there's no, again, it may be unfair, but it doesn't purport to say, well, he may be right, but there's a serious question to be tried, and I'm going to leave it all to the trial judge.
Right.
Estoppel by convention.
Now, just before we embark on estoppel,
Yes.
we are assuming, I take it, for the purposes of this ground, that you fail on ground 1.
Yes.
So the sub-lease came to an end automatically
Yes.
on the 14th of December.
Yes.
The tenant went into possession, even so,
Yes.
and paid rent at a rate calculated by reference to a period, probably annual.
Was yes, it paid the same rent as under the lease. It's quarterly payments of rent.
And I don't think you challenge the judge's conclusion that if those were the facts, leave aside any question of estoppel, then the conventional result of entry under a void lease and payment of rent is, at common law, a periodic tenancy on the same terms as the void lease, so far as consistent with an annual tenancy.
Yeah. You say I don't challenge the judge's conclusion that there's a tribal issue. It's a very strange situation because it's a situation where the tenant goes into occupation, pays rent, and both parties, as we'll see, subjectively assume that the lease is ongoing. So there's an argument to be raised as to whether the principles as expounded in Javid and Ackle what that results in.
All right. So there's a tribal issue on that.
Yes.
And if the trial judge were to come to the conclusion that that was indeed the situation,
yes,
there would have been a periodic tenancy,
yes,
held by the nursery,
yes,
in occupation for business purposes.
yes,
Therefore, Part 2 of the 54 Act would have applied to that periodic tenancy. And a periodic tenancy cannot be contracted out of the 54 Act.
That's right.
And therefore, the estoppel is one which, if it's effective, will deprive the tenant of statutory security of tenure, which cannot be ousted by agreement.
Well,
is that right?
No, I say it depends what your estoppel. That's the Keenan Holland point. And
exactly.
In my submission, it doesn't apply here because the estoppel. What the estoppel is, both parties assumed that the lease was ongoing. Yeah. It is perfectly possible to contract out of the protection of the 1954 Act, and indeed the lease was so contracted out. And the estoppel is a question of fact. Is the lease, are you stopped from saying your occupation is pursuant to this lease, which was perfectly validly contracted out?
Yeah.
That's the point. It's not a case where, for example, Keenan Holland, where both parties, as I understand it, in fact, it was accepted there was a periodic tenancy, which it was accepted would otherwise fall within the protection of one of the Agricultural Holdings Acts. But the alleged estoppel was, you are stopped from denying that this particular tenancy has the is within the protection of the Act, because that's what we've agreed. And it was said, no, this tenancy would otherwise fall within the Act, and you cannot by estoppel do what you could not do by agreement. Here we have the tenancy. The estoppel is, are you occupying pursuant to the terms of this tenancy, this lease, which is perfectly lawfully contracted out?
Yeah.
That's why I say it doesn't apply. I think the principle, if you go to my learned friends has cited Michael Barnes's book, which is, I think it's Divider 42. It's the last divider.
Yes.
And it's paragraph 5.1, as well as being considered in general terms as in the last part, the question of whether an estoppel by convention can apply so as to render enforceable an agreement which would not otherwise be enforceable. Consider more specific 3 types of circumstances. So that, I think is the principle. And the key here is that the lease those parties actually entered into, and which I say there's an estoppel by convention from denying that it continued or that you obey, is perfectly lawfully excluded. You can exclude the 54 Act. I mean, the Keenan Holland case is dealt with in the Tinkler case, which is Divider 33.
Sorry, 33.
Sorry, it's not 33. I've got the wrong reference.
37.
I'm grateful.
37.
37, that's right. It's page 571.
Yes.
And that's what they said in the letter C, paragraph 33. Court of Appeal held the landlord's argument based on stop by convention could not there succeed, was just an express agreement could not outflank the management provisions of the 1948 Act, so stop by convention could not do so. And then it's dealt with further in paragraph 79 to 81. And it's paragraph 80. We've examined Keenan Holland's paragraph 30 above. It's sufficient to recap those held as an estoppel by convention could not succeed because just as an express agreement could not outflank the management provision across those yet, so estoppel by convention could not. And then the first line of the quote from Lord Justice Oliver: once there is in fact an actual tendency to accept applies protection that follows, we do not see how the parties can effectively oust the protection. Protect provisions of that by agreement they should be treated as inapplicable. That's the point. Both parties there said, yeah, there is an agreement which would otherwise fall within the Act. But we have agreed that it won't be in those circumstances. But I made the point that it doesn't apply here because the estoppel concerns the continuing existence of the lease, which was validly excluded.
Yep.
If you look at the parties' subjective intentions, and I accept that's not enough, it's quite clear, I say, that both parties thought that the lease was continuing. If you look at Ms. Delaney's first statement, which is paragraph 47 at the supplemental bundle, page 24 of the supplemental bundle.
Sorry, just a minute.
It's page 24, divider 2
Yeah.
of the supplemental bundle, page 24, paragraph 47, right at the bottom. Before instructing solicitors and mistakenly believing that the lease was continuing rather than automatically terminating December 2014, the applicant had reasonable belief that would be able to seek a contractual agreement lease directly with the council. A number of informal conversations I'll come back to that because a lot is made of the factual merit here, but it's quite clear if you read paragraphs 47 to 52. Miss Delaney took a risk. She thought, until she consulted solicitors and perhaps even a learned friend, that she was occupying under the terms of the lease, which she knew was contracted out. Therefore, she knew she would have to vacate the premises on, I think, the 29th of August 2022, before the Christmas term started in September. And yet she takes no formal steps to seek a renewal. And there's no evidence that she sought alternative accommodation. She took a punt that she would be able to agree with the local authority and or my client a replacement lease. Anyway, but the point for present purposes is that she mistakenly believed that the lease was continuing until instructing solicitors, and we'll see that sometime in the middle of 2022. And she says again, if you go to her third witness statement, which is at page 342 of the supplemental on the divider 13. Paragraph 1D she's dealing with the supplement, the sub-lease. Once an agreement in principle reached with AMIA, we both instruct our respective solicitors. So it's the point I'm making that in respect of entering into the sub-lease, both parties have solicitors. And then she says, paragraph 6. Let's stop paragraph 5. AMIA never advised me of any difficulty in having producing the certified quality declaration prior to obtaining my I was preoccupied with managing private schools rather than scrutinising the regular lease. I was certainly never told by any of the deed not completed. I also don't believe that I requested possession of properties as you suggested by the 14th, but stated I don't recall precisely how the lease took place. But it's more likely that AMIA contacted the files when the handover took place, since the timing of the handover was dependent exactly when his residential tenants moved out. I recall receiving the email from the 18th September, December 2014, 1989, as it included the demands referred to the applicant paid the first account for the December 2022 and subsequent account 2025. I've not appreciated that clause 9 of the lease required Melcraft to provide a certified copy of the deed since my attention got withdrawn to it. This is why I never questioned it. I've no recollection or record of ever receiving the deed dated 11 June 2019 from Melcraft or AMIA, although I've had cause to look at other provisions, specifically the rent review clause and the parent obligations. I did not have cause to look at clause 9 until my attention was drawn to by my solicitors, certainly not informed of the deed dated 11 June 2019 as AMIA claims paragraph 17 was witness statement. Its allegation appears to be inconsistent with the statement paragraph 18 witness statement. The deed was not discussed about the application of obligation. Whilst I cannot say precisely what I would have happened if I had been aware of the consequences described in clause 9 of the lease, I'm certain I would not have reached it. So it's quite clear until sometime in mid to late 2022, Miss Delaney, the director of the respondent, was under the clear impression that she was occupying, or the company was occupying under the terms of the lease. If you go to Mr. Morin's witness statement, which is at 217 of that bundle,
Yep.
But he does say, in the meantime, planning wishes to change use was obtained by the claimant on 11th December. They obtained possession of property 18th at their request. Francis Lynn and I kept each other informed of the planning application deviation. I told her the variation was agreed with council. It was just a matter of agreeing with the terms of the deed.
That wasn't entirely accurate. Or was it?
Well, he said that that's his evidence. It was agreed in principle. It's simply a matter of haggling about the terms of any increase in rent. So, yeah, I accept it's a rather gnomic phrase there, but if you've seen the emails which were exhibited to his statement, there's nothing we would submit dishonest about what he's saying there, given that he's the emails that you've seen. And he says, paragraph 18, The deed was not discussed between the claimant and Belcraft after the claimant took possession of the property in the relationship continued under the terms of the underlease. Attached to 40 is an email from Francis Delaney, February 2015, confirming the claimant was commenced works between February and April 2015 at a cost of 96,000 excluding VAT. Thereafter, he received as per the terms of the underlease. For example, 22nd February, the claimant contacted me to carry out works to repair a pipe. Belcraft did the works contribution. And then he says at paragraph 27, later in 26 August, the defendant solicitors received a letter from the claimant solicitors alleging, amongst various matters, the claimant had a periodic tenancy and that the nursery was due to open on 5th September. This took me by surprise. It was the first time a periodic tenancy was alleged by the claimant. The defendant solicitors replied the same day denying there was a periodic tenancy. I would never have allowed the claimant to take possession on 18th December if they had told me that the underlease had ended on 14th December 2014. Further, if they had alleged this in the last few years, either Melcraft or defendant would have taken steps to take possession of the property unless they accept the underlease was not terminated.
What steps could they have taken
Well, if it had
to
been,
take possession if it had been a periodic tenancy?
we could have
protected
served a
by-
Section 25 notice at any time, giving 6 months' notice. We could,
Well, only if you had a reversion of 14 months or more.
yes, but for example, we could have some time after, if we'd been so minded, if it had been a periodic tenancy, if the nursery had spent as much as they said on it, we could have said, right, at any time after gone into possession and carried out the works, here's a Section 25 notice. We want to occupy for our own business. We want to carry out a nursery business. And they could have done that in good time to ensure that they were the relevant landlord under.
So was there some sort of duty to speak imposed on the nursery?
No. Sorry, it's my fault. I don't understand.
Well, you're saying if they'd been told. What he's saying is if he'd been
No.
told.
No.
If they had told me the underlease ended.
Yes, yeah. I accept there's no duty to speak, but if it had been asserted, as it was on the 26th of August 2022 for the first time, that in fact the respondent was not occupying under the terms of the lease as everyone had thought, but was in fact occupying under the terms of periodic tenancy, then there were steps which my client or its predecessor could have taken to secure its position, because it was under the impression that it had a period of 2 weeks. It had a lease which was not excluded from the 54 Act, and therefore it had a period of 2 weeks between the termination of the sublease and the term date of its head lease to secure its position in respect of, well, whereby you have to go into occupation and start to carry out a business from that. But if it had been a periodic tenancy, then you could have taken that step. You could serve Section 25 notice at any time, terminating the periodic tenancy, 6 months notice. And it could have said that notice could have said, well, we want to occupy. We could have said Section 31G. We want to occupy for our own business. We want to carry out a nursery business, which is what Mr. Morvin says he was trying to do in 2022, and there's some evidence of that, albeit my learned friend criticises that. But his position would have been much stronger. I mean, ask oneself this: had Mrs. Delaney realised, as she now asserts, in 2014 and 2015, when she went into the property and spent, she says, £250,000 refurbishing it, and she realised that all she had was a quarterly periodic tenancy, which could be terminated by the landlord with a Section 25 notice at any time, would she have spent that money? No one in their right mind would have spent that money, given the precarious or potentially precarious nature But we know that she went in and she spent the money because she thought at that time that she had the security of a lease which terminated on the term date, which is 29th of August 2022. But if she'd only a periodic tenancy, she's not searchable. My client could have served a Section 25 notice at any time.
Yeah.
But the point I was trying to make is that both parties, certainly until the middle of 2022, subjectively thought that the occupation was pursuant to the lease and not a periodic tenancy. And then, if that's right, if the respondent is now right, the obligation was on the tenant to remove the registration of the sublease. It had been registered. We can see that at page 238 of the supplemental bundle. The tenant didn't do that. The sublease remained registered. There was an obligation on the landlord to return the security deposit. That was not returned, and it was not returned. No demand was made for its return. The respondent entered into possession, carried out substantial works. As I've said, matter of common sense, that wouldn't have been done had she thought there was only a periodic tenancy. If you then go to page 264 of the if you go 266,
To what?
266 of the supplemental bundle.
Yeah.
It was 265, I thought.
I'm sorry.
Is it 265 at the bottom? That's the problem.
Yes, that's right. Yes, that's right. That's the 26th of February 2016.
Oh, that's it. That follows the first one. Yes.
Yes, as the broken pipe is, it's right the last penultimate line, as the broken pipe is an external one and not part of the lines of the line lease. I'm grateful. The 266, 267, and 27. Or 266 is a text exchange which takes place in a desultory fashion between 21st of February 2017 and 29th June 2017, where Mr. Morgan is attempting to implement the rent provisions.
Yeah.
Again, I don't think I've ever come across a periodic tenancy with a rent review.
You could have one.
Why would you bother? I mean, you could just terminate the tenancy and terminate the periodic tenancy and have another one. I mean, it's conceptually possible, I suppose, but I don't think anyone would bother. I don't know. The experience of property law in this court on the bench is much greater than mine, but I've never come across that. It's overwhelmingly consistent only with there being a fixed term lease and not with there being a periodic tenancy. I would submit. And that's what both parties thought they were doing.
I know it's statutory, but under an annual tenancy of an agricultural holding, you're entitled to periodic rent reviews. There's nothing inconsistent about it.
But that's a statutory.
Well, I
provision,
follow
isn't
it is, but there's nothing repugnant in the idea of a yearly tenancy, which is, at any rate, used to be before farm business leases, the standard form of letting agricultural property with a periodic increase in the rent.
Well, the very fact that it has to be imposed or recognised by statute would seem to indicate that it's extremely rare.
Is that the question?
Well,
If, as my lord put to you earlier, if you enter under a void lease and pay rent, the common law assumes you to have a periodic tenancy, subject to the same obligations as were in the void lease, insofar as they are capable of being applicable to the periodic tenancy.
well, suppose if my client had thought that this was a periodic lease. It's okay, we get a period, that rare creature, a periodic lease with rent review provision in it. And the tenant says, no, I'm not agreeing to that increase. The landlord would be perfectly enabled to serve a notice to quit or a say 25 notice. Say, right, I want a new lease now, and the rent will be what I say. So either way, I mean, this is I'm relying on this as a representation. In fact, both parties, it confirms what both parties subjectively thought, that this was a fixed term lease. And I suppose, yes, it is conceptually possible to have a periodic tenancy with a rent review provision, but the instance of those are vanishingly small, and so logically you simply terminate the even a 54 Act protected one, you'd simply terminate it and simply say, well, I want a new rent, please. I won't oppose, but the rent will be X, which is what I would have proposed on a rent review in any event. I think I've moved now to 283. This is, it's part of a lengthy email in 2020 from Mr. Delaney to Mr. Movin, and its installation of a new gate, which is the paragraph 283. As I mentioned to the phone last week, due to return to school, all the social distancing entrance exits, I'm sure you've done before. I'm writing a request as superior leaseholder, you allow Mr. Delaney to install a gate, allow families to enter through this new gate as it stands. We will, of course, meet all costs of our fence. We're allowed to use and make full repairs at the end of any lease we have with them. And he's referred there one with superior lease. Now, I suppose you could say that, well, leases ambiguous, it could be a periodic tenancy we refer to, but I submit it's better read as reference to the fixed term lease that both parties thought that they had at that stage.
Yeah.
286 is an email exchange in 2021. And this is, you will recall, just after the assignment by Melcraft to my client of the term in the head lease. 24th March 2021. Dear Amy, I'm currently waiting to join the Teams meeting, hence the quick email prior to settlement. This is a response to your text a few moments ago. The rent is due tomorrow. I felt I should send you a reply until I have opportunity to speak to you in person, to give us a platform by immediate reasons. I will not be able to make payment to any company other than Melcraft until I and my lawyers are satisfied. One, there's been a valid legal assignment of Melcraft legal leasehold estate in version, as Melcraft Limited estate and title is dependent on the superior lease of RBC, that interest under the lease has also been validly assigned. Till my lawyers advised I should make payments under the lease to another company or person, I must ensure payments are due. So she said, well, I must be assured that it's been properly assigned, quite right, I suppose. 24th of March, the reply at the page, dear Francis, thank you for that email. Please note the attached which should address your concern and lease. The response, dear Anne, at the top of the page, dear Anne, I finished my meeting and the opportunity to read your last email. Thank you for sending the numbers documents. Due to the poor mobile reception down on the West Coast, I've tried to call your mobile using my Irish home's landline and got your voicemail. Left a message couldn't say it was me. Found the number. And then over the page 285. Dear Francis, further to this is 24th of March, right at the bottom. Further to our earlier telephone conversation, I've rechecked with my solicitors regarding your position to change as far as
Sorry, where are you?
So I'm at the bottom of page 285. My by the way.
285, I beg
It's
your
one of
pardon,
these
yes.
wretched email exchanges which the latest
Yep,
one is,
yep,
but
yep.
I'm sorry if I haven't made that clear. I think it follows on from the 2 or the 3 we
Yes.
just read, and it's at the bottom of 285. Dear Francis, further to our earlier conversation, I've rechecked my solicitors, confirmed your position does not change as far as your lease is concerned. Your lease is automatically being transferred to Avondale. Given to Melcraft following the assignment of the head lease. In this light, please proceed to pay your rent to Avondale Park's account, not Melcraft. And then there's a further email 2 days later. Dear Francis, I know your rent has been paid in Melcraft's account despite my note before. I can only reduce this condition there. I will on your behalf forward these funds to Avondale Park's account. And then email Tom in response, dear man, on legal advice from my lawyers, I had to pay the money into Melcraft. I took the time to call you after receiving a WhatsApp message from you and not formal communication with Melcraft or the company dealing with the legal assignment in terms of my lease. Those terms do not ask me to transfer. My lawyers investigating the legal decision I disclosed to you on the telephone call. There's no evidence the alleged transfer has been registered with the land registry. There's no comment with the new company adhering to the terms of my lease, and I still have not seen the assignment of the buried landlord's obligation under the lease to the new company, along with evidence of transfer of security deposit held by Melcraft and fresh covenants from the new company to repay the security deposit at the end of the term. These issues what my lawyers are looking into. So, in my submission, she's taken legal advice, and in my submission, that can only be a reference to her, what we know is her subjective view, not yet disabused by her lawyers, that she had, she was occupying pursuant to the terms of the lease.
Yeah.
If one goes then to 287, this is the letter from the 7th of June, so a couple of months after the exchange we've just seen, from the my client's previous solicitors to Mr. Delaney, property Avondale Park Lodge, lease. The underlease of the property dated 9th September 2014, made to Melcraft Ltd. Moving, Delaney's Nursery Limited, former landlord Melcraft, new landlord Avondale Park. We have to have your former landlord, new landlord, former landlord transferred ownership of the property, new landlord in January, pay all future rents from 21st January 2021, other sums due under the lease to the new landlord. And that was done. 288. I think this is March 2022, and it's a text exchange, but it's the middle one. And this is where, as Mr. Delaney says, from March 2022, she didn't pay any rent under for the property. She says because she.
Where do we get the date from?
Well, there's no date on this document,
Right.
but it's clear from both parties' witness statements.
Yeah. This is March.
March. I think it's from March 2022. That March quarter was not paid.
Yeah.
Nor was the June quarter. And you'll see the evidence from Mr. Delaney says that that's because she had concerns about the solvency and the ability to repay the security deposit. And this is as you see at the top, hi Francis, I'm disappointed not to have received this quarter's rent. And that's a reference to the 25th of March 2022 rent. But it's the text below. Amir, we discussed this only a couple of days ago, and you know why the rent has not been paid, and my concerns about the renewal of the lease and the repayment of my security deposit under the terms of my existing lease. These matters are now in the hands of my lawyer, and your lawyer needs to speak to him and provide with information on the issue of sub-lease. Until I'm satisfied your company has the means and intention to repay the sum of approximately 60,000. Accordance with its obligations on the expiry of the current lease, regardless of whether or not the new lease is going to be, I'll be guided by the advice of my lawyers as to what's the appropriate course of action to adopt. If you want to adopt any complications, be full transparency with your lawyer. So that's only consistent with the occupation being pursuant to the sub-lease, which has a term date. At 289, there's then an email from the respondents then and current solicitors, 31st March 2022, addressed to the appellant's former solicitors. Dear Roger, I understand you act for Avondale Park. As mentioned yesterday, I act for Mr. Delaney's Nursery Schools, who is your client's tenant of the above premises. As As you may know, my client's lease dated 9 September 2014 expires on 28 August 2022. Understand the head lease held by your client expires on 13 December. Please confirm your client's intention to renew the lease terms. Again, couldn't be clearer. Again, 290. This is 14th of April 2022 from again the appellant's former solicitors to former solicitors. Dear James, thank you. I'm considering this my client will work to email form completed. Understand this but few exchanges between our clients as to the normal rent and your clients concerned the rent deposit. Rent deposit can only be dealt with at the end of the term and your client should continue paying the rent due to my client. I think the response to that is 291. Again, solicitors exchange. Dear Roger, I understand our clients have spoken. My client confirmed I would be in contact with them. Call. My client has the following questions. 1. Will your client be in a position to grant a new lease to Mr. Delaney's Nursery School Limited when my client's lease expires on 28 August 2022? Can your client and secondary executive beneficial owner client confirm there has been no discussion or suggestion by the County of Chelsea regarding any financial or voluntary involvement in Mr. Delaney's Nursery Schools Limited? Therefore, the only relationship your client minds is that of the tenant with the tenant and so on. Please confirm who currently holds the rent deposit. My client is concerned by a number of issues related to the rent deposit. Will it your client to repay the deposit at the end of the term of the existing lease? That response to that is 292, 8th of June 2022. Thank you for your email. Reply should appear as follows. Not the numbers my client will need to renew their own lease. There's been no discussion with the council. I'm instructed that the deposit is held by my client. There's a further on chase up on 293 from again respondent solicitors. Dear Roger, apologies today. My client wants to renew the lease. Please confirm the proposed terms of the lease to my client. Proposed head lease terms will be at the head lease in days before the after lease is granted. Possibly spirit landlord's consent on the let. 294 in August 22. Solicitor for the appellant. Sub-lease ends on 28th of August and your client will need to hand back the keys on that day.
Sorry, where are you?
I'm at
Oh, yes, got it. Yep.
Sorry.
Yep.
And then a similar letter, 19th of August 2022. This is, I think it's 10 days before the term date of the sub-lease. It's from, again, the appellant solicitors, Mr. Delaney, premise date, Carr. Lease, sub-lease, and it says here, the under lease is due to expire on 30th August 2022 and the landlord becomes taking the premise on that date. There's your possession. So again, clear assertion. And that is chased up on the next page, 296. James, I just spotted one there in the letter. The under lease expires on 29th or 30th. Can you please confirm your client's providing the keys? Now, my client then purported to forfeit by changing the locks on the, I think it's the 26th. I accept that was not lawful, albeit it was 2 days before the term date of the sub-lease. And then on that date, we get the letter of the 26th of August 2022, which is at 297 and 299. And that is the first assertion that is made 2 days or 3 days before the term date in the sublease, that in fact the sublease doesn't exist and indeed hasn't existed since December 2014, and in fact, unbeknownst to either party, the respondent has been occupying under a period of tenancy protected by the 54 Act. What appears to have happened, in addition to the changing of the locks on the 26th, is that if you go to the first page of the supplementary bundle, again, this is unbeknownst to my client. On the 11th of July 2022, this email was not before the judge. Although the response to it was. And this is, it's the respondent solicitors on the 11th of July right to the Royal Borough of Kensington, Chelsea. Dear Henry, outstanding meeting. I find your legal team has confirmed the Headley is currently investigating the past protection order on Tenant 24, so the council are unable to engage my client directly. Please can you either let me liaise with your legal team directors specifically? And then there's the first hint there that there may be a that the sub-lease had terminated under clause 9. That, of course, is not shared with my client until the 26th of August. So someone has taken some advice.
Yeah.
Come up with a reason. Gosh, let's get some protection for clause 9. That's responded to by the council at page 154. This was before the judge, and hence
154. Did you say?
154 of the supplemental.
Yeah.
It's addressed to again. We only saw this when it was disclosed. Nobody's first to do so. It was next to a statement. But it's Kensington, Chelsea, dear sirs, we act on behalf of the Royal Borough of Kensington, Chelsea, and are instructed to provide a response to your email on the days 11th July 2022. That's the one you just read. And they recite Plant's freehold owner. They recite the head lease, the next paragraph. They then recite the sub-lease, the next paragraph. You make several points in your letter, which are some, I suppose. Contractual term of the lease has expired on its own terms on 14th December 2014. Your client's continued occupation since its tenant will periodic tenancy head lease. Avondale Park fails to meet the qualifying criteria of section 3, therefore was protection. Our client should consider granting an overriding lease to your client. We have carefully considered your letter arguments made, which unfortunately do not review the analysis of the implication by acts of other parties. Now, given that Miss Delaney says that she has entered into negotiation or sought to reach out to the council with a view to securing her position for the coming term in September 2022, it doesn't appear that she got much joy, because here the council are completely rebuffing her. They said that the first paragraph is there. We wish to add, and I'm at 155, we wish to add that prior to receipt of correspondence from yourselves with the client, RBK said already considered two key issues. One was whether Avondale Park was contracted out of the 54 Act. Another question our client considered was whether Avondale could be considered a contracted out of the Landlord Said Act. We note that this query is to be made. Parties agreed by the terms of that lease that it would not fall within the provisions of the Act. You'll be well aware, however, that these provisions are contingent on receipt of a notice under section 38A3 of the Act. Unfortunately, the records of our client show that these processes were never complied with.
Would you be stopped from denying that you'd received the requisite notice under section 38A?
It's never been said that we did. I don't know. It maybe you won't, because that is something you can't contract out of if you wanted protection. It's a different situation. That would be if that was to be said, we would say that's akin to the Keenan Holland situation, which is not the case here. But it's never been alleged by anybody that we are. And certainly the landlord, that is RBKC, and the tenant, that is respectively my company, neither party has said there's anything to stop. The parties agreed that unfortunately records show that these processes are never completed. The RBKC has already litigated in similar matters involving the same facts and satisfied that the court will not in these circumstances assume the terms of the lease in favour of our client to resolve that ambiguity. The client also has a responsible, prudent approach to litigation, bearing in mind also the interests of public law. So there's the assertion. It soon, perhaps for the first time, to Mr. Delaney, that in fact, if she had assumed that her landlord's head lease was excluded from the Act, it's not.
Yeah.
The other question the council considers whether Avondale Park is in breach of the lease, having sublet the entire premise and thereby having no physical presence on the premise, carrying out business there in any form in this regard. You contend the lease does not fulfil the qualifying date section 23. We note to support this point your client's email correspondence dated 11th July. It sets out a quote there. And then it says, council is fully aware of the facts asserted by your client. The RBKC granted consent to Belcraft Limited, so letting the premise to your client. On 11th December 2014, the Council granted full planning permission for change of use from commercial class C to residential nursery school. To demonstrate here, the Council would have been aware and viewed the application of sub-lease. The leaseholder would henceforth not be present on the premises for the purpose of carrying on business, and we have little doubt that a court of law would such fact be not think any basis the Council consider. So they are asserting there that they did in fact consent. The RBC granted consent to Belcraft subletting the premises to your client. So whenever it was, consent was granted. We also do agree with the issue whether or not Avondale Park is breaching some lease and after RBC says opposed to the question whether the leaseholders have breached their lease. As landlord, our client's only privity is the lease between itself and the lease. See, the other part issue for our client is whether the current lease falls into the provisions of 54 Act. We're not clear how any points raised in your letter demonstrate Avondale Park Limited's breach of that lease amounts to an actionable breach of the lease dated 12th September 2022. We do not believe the lapse of your client's under lease infraction tendency within the under leases capable of triggering termination. We also have not agreed with RBK saying unlawfully grants and overrides a lease to your client. Such time as this operation, the lessee Avondale Park has the right to possession of the property, whilst RBK understands the position of the client is unable to interfere with Avondale Park's Limited's right to craftsmanship of the property, so the Council's act otherwise it's blatant disregard of contractual rights. And then it's hoped that your client is able to find a solution to issues characterised with the park that will get the Council continues to monitor the situation with the leaseholder. Any meaningful discussion the Council can have with Mr. Leech Nursery can only be when the current lease is terminated, or should the Council act to take steps to terminate. This is not currently the case. So one can imagine at that stage a degree of panic on the part of the respondent, in that they had a new term starting in a month's time and had not secured their premises, which they had until hitherto assumed would be terminating on the 29th of August 2022. Hence, they then, and there's no evidence that the respondent sought alternative accommodation, and there's no evidence that they seriously sought to negotiate with either the Royal Borough of Kensington, Chelsea, or my client. Hence, one gets to the stage, I accept that it was my client's unlawful forfeiture which kick-started this, whereby you get what we say is the construct of alleging that the lease has terminated, and in fact, contrary to all subjective assumptions and contrary to the objectively viewed correspondence passing between the parties, in fact, there had been a protected periodic tenancy at all material times since late December 2014. Now, in those circumstances, we submit that it is beyond doubt that an estoppel by convention has arisen. The law, if I can take you simply to, if you need reminding of it, there is the passage in the Republic of India case, which is at divider 23 of the authorities, but I think we cite it in our skeleton.
Yes, you do.
I won't take you.
But it's all in Tinkler now, isn't it?
Yes, that's divider 37.
Yeah. Slightly modified version of bench dollar.
That's right. It's paragraph 45. Okay, they set out paragraph 39 at 574, divider 37, 574, but they set out that passage in one Republic of India is one of the cases they consider, and then they deal with the relevant passage. In paragraph 45 is the passage from the judgment of Justice Briggs in the bench dollar case.
Yeah. And then at 49D, you make the addition, you amend the first principle to include crossing of the line.
That's right. I mean, as I read crossing of the line, it simply means that it's not good, it's not sufficient for there to be an estoppel by convention that both parties actually subjectively thought that for example, here they were occupied. There has to be some sort of objective communication between the two.
It's not enough to have a common assumption, you have to have a shared assumption.
That's right. And in my submission, that's precisely put. And we say there's plenty of sharing here.
Yeah.
And if I have to submit, I will submit that there can be no possible factual dispute. The facts are before the court. Indeed, the facts are clear and admitted. It's never said that until 26th of August, the respondent sought to disabuse my client of the impression that he had. And so we say it's clear beyond peradventure that the judge ought to have found that there was no serious issue to be tried on that.
Yeah.
Can I then turn to ground 3?
Sorry, just
Sorry.
so I understand, your position on detriment is...
Well, detriment is set out, albeit briefly, in paragraph 27 of Mr. Morvin, I think it's 27, where he says...
He says, I wouldn't have let them in the first place.
Yep.
That doesn't work in terms of
temporary
detriment, does it?
Yes, I think it's paragraph 27 at page 219 of the supplemental. He says, paragraph 219, I would never have allowed the claimant to take possession of 18th if they had told me they were unleased.
That doesn't work, does it? All of these later shared assumptions post-date the taking of possession. So where's the, as it were, the detriment?
Well, further, if they'd alleged this last, either Melcraft and them would have taken steps to take possession of the property unless they accept the underlease had not been terminated. So that's the point of saying we could have, if it had been said to us that we had there was a periodic tenancy here. We know that we have a fixed term tenancy which expires, I think it's September 2020, 13th of September 2022, which is within the Act. In order to secure our position there, we have to be in occupation, under the 34 Act, we have to be in occupation trading as a business. It would have been, if someone had said, oh, by the way, some stage between 2014 and 2022, by the way, this is a periodic tenancy, we could have served a Section 25 notice and obtained possession under Section 31G. We could have occupied for our own business. We would have taken
business being...
Well, we could have done a nursery business. This is what
Really?
well, I say that because that's what, albeit the evidence is criticised, that's what Mr. Morvin said that he is trying to do.
Well, are we going to look at the evidence?
Well, it's...
The string of emails, every single one of which postdates the 2nd of September.
Yes. Well, if it
And
is...
in the 9 days in which your client was in possession, they did nothing.
Well, we preparatory work, so you
What
see
work?
the...
Where's the evidence for that?
Well,
The only evidence is that you arranged for a plumber and an electrician to go in on the 12th of September,
Yes.
day before the lease was due to expire.
In these circumstances, my lord, I rely upon that evidence as evidence of detriment in the sense that when we were faced with it, we took steps to trade as a nursery. I accept
And
that.
if we are to do more than consider whether there's a triable issue, are we to take a view about the quality of that evidence?
Well, in my submission, there is clear evidence of detriment, as set out, albeit briefly, in that statement.
Well, it's half a sentence.
Yeah. Well, it's evidence of detriment, and it's not exactly unexpected, my lord. It's not as if it's contrary to what you might expect. Here we have evidence that, albeit you might say it's tenuous, that in the fag end, or in the period of fag end of the head lease, Mr. Morvin is trying to get established a nursery business. Now, that may be criticised at that time, but it's not nugatory. But if it is said that, well, how can there be any detriment? Well, we know that when he is faced with it, he does try and start that business. So if it is said, and I say that the detriment is that if he's been told 2015, 2016, 2017, this is a periodic tenancy, it's not going to end unless you terminate it, and it's within the Act, he would have terminated it. And the evidence is that when he gets possession, he tries to run or starts to try and run a nursery business. And for the person of detriment, I say that's sufficient, more than sufficient. And indeed,
can I ask you a slightly different question?
yes.
Go back to Mr. Justice Briggs, as he then was, statement in bench doc.
Yes.
Paragraph 45.
Yes.
Little 2. The expression of the common assumption by the party alleged to be stopped. So here, Mr. Evans, must be such that he may properly be said to assume some element of responsibility for it, in the sense of conveying to the other party an understanding that he expected the other party to rely upon it, and the person alleging the estoppel, here your client, must in fact have relied upon the common assumption rather than merely upon his own independent view of the matter. Now, in what sense does Mr. Morehaven rely on, oh, well, Mr. Delaney is saying they've got a lease, that's what I'm going to rely on, rather than, well, I assume that she's got a lease, we both assume that. Well, and when you look at the statement in paragraph 27, what he says, which I understand is, well, if I'd been told that this underlease they weren't occupying under the underlease, then I would have taken steps. It's not clear to me from bench dollar whether that's the question. The question is, was it Miss Delaney saying to him that they had a lease which caused him to act in any particular way, or was it because that's just what he thought himself?
Well, it can be a combination of both. It's unrealistic, in my submission, to divide it up in that way. One's at risk of taking an unduly technical view of this. When it says, for example, some assumption, the expression that such a properly said of assumed responsibility, I've read that as assumed responsibility for the statement which crossed the line. It wasn't someone else's statement, it was the statement of someone, either the person said to be estopped or someone authorised by the person said to be estopped. But it's a combination of both. It must be, surely in every case, if most cases, where you have two things. You have a subjective view of both parties here, that the occupation pursuant to sub-lease. Which
Let's assume you're right. Your legal proposition is right. If there were to be a trial, it would be a perfectly proper line of cross-examination to put to Mr. Morehaven, would it not, that you didn't rely on anything that Mr. Delaney said, you simply formed your own independent view. And if that were to be put and agreed to or found by a trial judge, then reliance would disappear, wouldn't it?
Well, reliance, there must be an objective element here. What happens is Mr. Morehaven is clearly of the view that the lease is continuing. That's his view. And that view is confirmed by the correspondence we've looked at.
Yeah.
Now, it's splitting hairs to say, oh, well, you had the view already, and you didn't rely on anything said because you clearly had that view already. And therefore, nothing Mr. Delaney could possibly have said to you subsequently could disabuse you of that view. And it's an unrealistic attitude to take. There must be a degree of common sense here. I accept that you can divide up estoppel by convention into legal principles and points, but at the end of the day, you have to apply those to circumstances, a range of circumstances such as this. And the truth was here that both parties thought right from the start that the lease was continuing. And both parties confirmed that impression to each other in correspondence. Now, it might be said, you didn't rely on it because you already had that impression. But that was a case, he had the impression the lease was continuing, and it was never disabused, and he saw that Mr. Delaney was of that view as well. It would be overly technical in my submission to be able to say to a judge, well, he didn't rely on anything Miss Delaney said because he already was of that view. that must be the case in every estoppel by convention case. The point of an estoppel, it confirms something objectively.
But it's a different. Estoppel by convention is a different type of estoppel to estoppel by representation. Self-evidently.
It is technically, my lady, that's right. But it's all based on common assumptions. Which common assumption is shared? That's the case here. Now, it's said, if it is said that, well, you didn't actually rely on anything, Mr. Delaney, said that's unrealistic because he already had that view. And that's why he says, if she'd told me otherwise. Because I had that view already. I knew Mr. Delaney had that view already. And we corresponded on the basis that of our common assumption was right. We shared that common assumption. But that common assumption arose prior to or at the time of going into possession. And so it's a little technical to say, aha, you need separately as well to say, my assumption was confirmed and by Mr. Delaney and I relied upon it. When in circumstances where you already have the assumption, both parties already have the assumption.
Yeah.
So I would submit that, yes, it might be possible to cross-examine Mr. Movey on the basis that we didn't rely on him. He might say, well, yeah, I didn't because I already had that assumption. It was already there, and Mr. Delaney had the assumption, and the correspondent simply confirmed it. Sorry, I've tried to answer that,
yes.
that question. I'm supposed to move on
Thank
to
you.
ground 3, if I may. If you look at American Scientific, which is at divider 15. At page 166. I'd like to just draw your attention to a number of passages in the judgment of. If you go to 176, page 406C of Avondale. Lord Diblock says this: my lords, when an application for an interlocutory injunction to restrain a defendant from doing acts alleged to be in violation of plaintiff's legal right is made upon contested facts, I emphasise that. The decision whether or not to grant an interlocutory injunction has to be taken at a time when except offside it isn't the right of violation of it, or both its of it is uncertain and will remain uncertain until final judgment is given the action. And I emphasise that upon contested facts, because my submission that there are not many contested facts here. And then he goes on, I'm taking it up again at letter F at that page. In those cases where the legal rights of the parties depend upon facts that are in dispute between them, the evidence available to the court in the hearing of the application for an interlocutory judge is incomplete. It's given an affidavit and has not been tested by all cross-examination. Perhaps sought to be achieved by giving to the court discretion to grant such a judgment to be stultified. Discretion will clogged by technical proof, being exercised by the incomplete, untested evidence. The court evaluated the chance of success in the 50% or less, but the exercise of the court about 50%. Again, the emphasis on facts in dispute. I'd like to take it up, if I may, at the next page, 407 of the report 177, the bundle, at letter G. Your Lordship should, in my view, take this opportunity of declaring that there is no such thing. The use of such expressions as a probability, a prima facie case, and strong prima facie case in the context of the exercise of discretionary power to grant a legal injunction leads to confusion as to the object sought to be achieved in this form of dispute. The court, no doubt, must be satisfied that the claim is not frivolous or vexatious, in other words, a serious issue to be tried. It's no part of the court's function at this stage of litigation to try and resolve conflicts in evidence or affidavit as to the facts on which the claims of either party are likely to defend, or to decide difficult questions of law which call for a detailed argument or mature considerations. These are matters to be dealt with at trial. One of the reasons for the introduction of facts requiring an untaken grounds for granting this injunction was that it aided the court in doing that which was its great object. This abstaining from expressing any opinion on the merits of the case. So unless the material available to the court in the hearing of the application for an interlocutory injunction fails to disclose the plaintiffs any real prospect of succeeding in this claim for a permanent injunction trial, the court should go on to consider whether bounds the that's the standard test. It's whether it's not frivolous, not vexatious, or serious question tried, or any real prospect of succeeding, although real prospect of success now has a rather technical meaning. I think it's the summary judgment test, real, or it's the appeal test. So that's it. Some idea of that. But I emphasise that the paradigm that Lord Diplock is looking at there is a case where there are contested facts. Except he says you shouldn't decide complicated questions of law. But standing back here, there are not many, if any, contested facts. In fact, there are no relevant contested facts.
Well, this is the approach the judge clearly identified and took at para 27 in the judgment.
Yes, he did. He was directed.
In terms,
yes.
I think, I can't resolve this without oral evidence. And he gives 6 reasons.
Yes.
They include the fact that Mr. Moavin had been receiving legal advice, and it wasn't clear when and what and in what terms that advice had been given and received. And so it couldn't be clear when there was this shared understanding, and whether Mr. Moavin had himself proceeded on this clear assumption. And then we go back to concerns or issues that the judge thought were triable on the question of detriment, which you haven't really focused on at all.
So which
the 2 paragraphs where he identifies the issues on detriment that he thinks would require to be explored.
I was coming to that now. Paragraph 1, he says there's no clear evidence in this poem himself proceeding the clear assumption statement. But that's wrong. I've taken you to paragraph 27. It may be a brief statement, but it's quite clear from paragraph 27, indeed paragraphs 18 to 27 of Mr. Golding's statement, that he did. He assumed that the lease was ongoing, and indeed that assumption is confirmed by the correspondence. So I think my submission would be the judge is simply wrong.
Right. And then the next 3 paragraphs, I think, are 1 point, in fact.
Well, deal with each. Mr. Brompton corresponds to that I should draw the interest as those aware the lease had come to an end. I haven't seen such correspondence. In my submission, it's not there. There is nothing. Maybe my learned friend will take you to submissions in response, but there's nothing that I have seen whereby it could be said that Mr. Moavin was sent after the 14th of December to assume the lease had ended. Quite the opposite, I would say. But I think it's clear by the middle of 2014, France was not prepared to enter and execute the deed of variation. To be legal, yes, that's right. But the whole point of clause 9 is that it didn't matter what the reasons for the failure to produce the deed were, good, bad, or indifferent. If the deed was not produced, if I'm right, the tenant had an option, or indeed either party had an option to terminate. So whether my client was being dishonest or dissembling, and I said there's no possible basis for saying that that's right, although the learned friend makes great play, it's simply not right. And I would submit the judge got it wrong there. And 4, claims that were receiving legal advice during the period. Yes, he was. Both parties were receiving legal advice in the period up to the date of the lease, the grant of the lease. But there's no evidence there was legal advice at any time after that, and in particular at any time after the 14th of December 2014, which is the key date in respect of clause 9. In fact, the only person who was receiving legal advice after that is repeatedly from 2021 Mrs. Delaney, who keeps saying that, despite the fact she says she's got legal advice. Her legal advisors until 26th of August assert that there's a lease which is going to terminate. So, with respect, I think the judge is wrong there, or he's mischaracterised there. And I submit that the judge is wrong when the totality of the evidence which was before him, and witness statements looked at, to say there's any doubt about a common assumption. Both parties accepted that there was. Both parties, in my submission, and that that assumption was shared. Indeed, there's nothing to the contrary until the letter of the 26th of August. So, Milady, I think the judge, I was going to deal with him. The judge is wrong on that, I say. Further, I canvassed Mr. Pets, I'm doing 5 now. Defendant had suffered, made unconscious. That I was in judgment decidedly thin. I accept Mr. Moffat's criticism of plan to set up a nursery. Well, with respect, it may be right. You may be right to criticise the plan, but the detriment arose before that, I would submit, in circumstances which I've already addressed you on. And again, I accept the evidence is brief, but it's there, and in fact, it's entirely understandable. It's not as if Mr. Mulvey's saying anything that's contrary to common sense or contrary to commercial common sense, what you expect. And then 6, he says, in particular, I take the view that defendant will only be able to establish that it suffered detriment, which would prevent the claim from resulting from it, if it's able to show that it would or have been in a position to acquire a new lease. Well, that's not right, because he's dealing with detriment purely in the period between expiry, the term date of the sublease, and the term date of the head lease. But that's not the detriment was suffered before that. That was detriment, but it was suffered long before that, because, as he says, he would have taken steps had it been asserted, had he been disabused of the common assumption at an earlier date, he would have been able to take steps to secure some. So, I say, far from strengthening the position, the judge, if you examine the judge's reasoning of that, it doesn't bear scrutiny, in my submission, and he's simply wrong in a number of respects. So, I'm sorry, I'm dealing with the back to deal with whether there's a serious issue to be tried on detriment, and I say there's not. But yes, I was going to deal with that. I had it in my notes.
Yeah.
So, it's well known, but in my submission, if I take against myself that this appeal is not nugatory, and I've set out the reasons.
Yes, I was going to ask you, what good does it do you?
Well,
you've got to produce a very elaborate construct based on Poynton and York and Lewison and Manders. And you're saying, in effect, that the Royal Borough must treat you as if you had been in occupation for business purposes in the period immediately before the head lease expired, although you weren't, and that you should be treated as having continued in occupation since then, which you weren't.
Because we've been excluded
because the court has excluded you. And therefore, that's a reason beyond your control.
Yes.
But whatever the position between you and Miss Delaney's nurseries, why should that bother Kensington?
I put that in because I've no doubt it would feature, but at the end of the day, you don't get to that. If I'm right, this injunction should never have been granted. And it's not a sufficient answer to the appeal to say, oh, well, tough luck. You know,
well, except if we discharge the injunction, the moment Miss Delaney's nursery school are in there, as I understand it, and trading, what right have you got to go back if the injunction is discharged?
Well, we say we've got that right. We say, look, we were physically in possession. We were taking steps, preparatory steps, to start a nursery business.
That's the email chain of the 3rd of September.
We can take steps, and we were been excluded wrongfully on this assumption by the court.
Yeah.
And we are entitled to take our chances with the Royal Borough of Kensington Chelsea with that argument. At the very least, then we'll be entitled to damages. But that's the point. It's not nugatory. We're entitled to our negotiating position. We're entitled to say, Royal Borough of Kensington, right, look, we were wrongly excluded from these premises. We could have been in occupation between 26th of August and the 13th, or 29th of August and the 13th of September. As you see the attitude of the Royal Borough of Kensington Chelsea, they weren't prepared to deal with Mr. Delaney until the situation was sorted out. There's no reason to suppose, my learned friend asserts twice or three times in his skeleton that the Royal Borough of Kensington Chelsea wouldn't deal with my client. There's absolutely no evidence of that at all. In fact, the evidence of that letter is exactly opposite. So we're entitled to say the injunction was wrongly granted. No, this is what happens.
Well, if it's a question of damages, then you can go to trial and, if need be, enforce the undertaking.
Yes, but I'm entitled to say, well, I want it now. I want the order should never have been granted. We should never have been kept out. And the longer it goes on, the more we get prejudiced.
Can I go back to one point on ground 3? The judge records that it was common ground that American Sign made a plant below.
Yes.
Are you able to come to this court and say he was wrong about that?
My submission, well, it depends what you mean by American Sign. And it's quite clear. If you look, for example, at my learned friend's skeleton below, which is in the Carr.
Which of your learned friends? Mr. Moffat or Mr. Pett?
Mr. Moffat. I have many learned friends.
No doubt.
If you go to, it's page 141.
Well, the judge took his formulation from Mr. Pett's skeleton. See paragraph 13.
Yes. Well,
So page 141, is that right?
sorry.
That's my
It's, yes, it's 135 it starts with that.
135. Yeah.
And my learned friend stresses the judge, American Sign of facts, case consideration. No 38, principle of the hearing interim injunction, the court should not seek to evaluate the merits of the parts beyond the satisfied trial issues, not always applied complexly. Some investigation of merits has been undertaken in case where the granting of usual injunction would effectively dispose of. This case would not be correct to state the grant of usual injunction would dispose entirely of this case. Declarations as to the state's of the applicant's occupation, lawful censorship, or forfeiture, to any additional damage claim would still need to be determined. However, the need for a permanent injunction restoring the applicant's property may well fall away as an injunction to do so like last the reversion claim. So the learned friend makes the point to the judge, and that's within the American Sign of the test. That's the point. I'd say Lord Diplock is dealing with cases where there are factual disputes, and then if you go to say 3942, he deals with that, and then at paragraph 70 at 141, my learned friend said, it's submitted that weighing the relative merits of the parties' positions in this way suffice to determine the justice of the case, and an injunction should be granted. So that's the higher test. So my learned friend clearly spotted the point that this was a case where it might be said that the granted injunction would effectively determine the case. And indeed, if the points you made to me, or Justice Lewison made to me, are correct, then it effectively has determined the case. So it's a case where we say, it's a classic case where the judge should apply a higher threshold.
Yeah.
I suspect it may be said that's what he did on Clause 9. It's not what he purported to do in respect of the Stockholm Convention.
Yeah.
And that's the point. My lords, I note the time. I think I have finished.
Right.
If I might just re-look at my notes.
Yes, of course.
I hope I won't bother you further after lunch.
Right. 2 o'clock.